To discuss the implications for judicial practice, I'm joined by Lisa Hayes, June Maresca, Donna Gray, Andrea Moen, and Jean Clinton. Lisa, what are the potential risks that may be associated with custody and access orders specific to a child's mental health?
Well, I think like in a family conflict or family violence scenario, it'd be really important to make sure that you're tailoring the access to avoid the young child being exposed to further conflict. For example, you could create an order that provides that where there is family conflict between the spouses, that a third party would be involved in doing the transfer of the child from one parent to another for that access. You may also want to think about whether supervised access is necessary for one or both parents, depending on the kinds of risks that they may pose to the child. And within the child protection context, the Children's Aid Society would need to point out the evidence in support of supervised versus unsupervised access and whether a parent can manage the access. So that's the one big issue that comes to mind there, how to make sure that the child is safe, and the specific access order has to be geared to the specific risk present in the case.
Yeah, and I would add, it requires that the source of toxic stress for the child is identified. So that comes back to, you know, how do the judges and how can the judges find out? Because if a child is going to be continuously exposed to a stressor in a person, then all of the goods that may be being done outside of that is undermined. So this concept of toxicity of the environment, I think, is a guiding one.
Andrea, what kinds of orders can be made to take into account what would be appropriate for infants and toddlers when we're talking about access and interventions?
That's a very large question, because when we're talking about infants and toddlers, we're usually talking about them in the context of a family which can have children of varying ages, different parents, some parents that are working far away, for example. We need to look at whether or not there is one of the family members that can be a buffer and make sure that that person is given, especially for an infant, probably a great deal of time with the child. We need to take into account how we can protect the child from the toxicity in terms of the access of the other parent. We can probably give grandparents time if that is going to be a way that we can handle these sorts of situations. There are many things that we probably could do, but the most important thing is to think about the particular child and the particular family and try to get evidence about the relationships, because we so often get the dueling affidavits where each parent is so bent on talking about how bad the other parent is that it's very hard to sift through that and come up with those answers. But I think as judges, we need to try to do that.
June, what do you think judges should be looking for when they are dealing with scenarios similar to the ones we've been watching?
I think that we need to be very careful as judges that we create an atmosphere of problem solving in our courts and try to diminish the emphasis on the adversarial, because the more the parents see each other as adversaries, the more they see themselves as adversaries with the Children's Aid Society, the less they are going to be able to attend to what they have to do with this child, the less energy they're going to bring to that, and the more difficult it's going to be for the child in the long run, because they're going to bring that conflict, that stress into the home. And I think the other unfortunate consequence is that no matter what orders we make, I think as judges we know in a family context, anybody can sabotage it. So we can make order after order after order, and if the parent isn't going to buy in, then they can sabotage that order, and that child is in fact much worse off than they were to begin with.
Well, just following up on that last point, I would think judges should be asking, have you tried mediation? Have you, because I think particularly in child welfare, it's often thought that mediation is not effective in child welfare, but I think that there is within the Act, there are points within the Act that we are required to consider alternative dispute resolution. I would like them to ask that. I would also like judges to be asking, how long is too long? Because I find, and it's certainly not, it doesn't rest solely on the judges, it rests on all the participants in the process. But there are timelines built into the Act, but more and more we go past them, we exceed them. And so if I was a judge, and what I'd like to see from a judge is how long do you give a parent to put together a reasonable plan that would be adequate for the child's needs. And I think that question gets lost often.